So, not September 3rd, when it. October 8th, then. So hopefully I made that. I don't have to be fine. Worst case scenario. 26063. Yeah, and people. I have another one that I'm gonna answer.
Hey guys, somebody's got their mic on just in case you didn't mean to.
Oh, Joy.
All right, good morning. It is 8:30 a.m. on the 20th of August. This is the regularly scheduled status conference docket, although it looks like we might have a few other types of cases on the docket this morning. So I will begin with case numbers 259, 12, 13, 14, and 15. These are Matador Production Company. Entry of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant in these cases. And it's actually, we filed, it's Greyhound Resources LLC with Matador Production Company as the designated operator in the applications.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2 and also on behalf of Stanlin Permian, Stanlin Stevens, D&H Davis Oil, AG Hawk Permian, Yield One, and Pig Brothers. And for Avant, we originally objected to the cases moving forward, but we withdrew our objection. And for the other Stanlin parties, we're just monitoring to preserve rights.
Thank you.
Good morning, Mr. Hearing Examiner. This is Ann Tripp of Hinkle Shaner on behalf of Permian Development, LLC.
And your client's position?
Mr. Hearing Examiner, we've requested that this proceed to, we objected to proceeding on affidavit, requesting that this proceed to a full hearing.
That's my understanding too. Ms. Tripp and I have been in communication. My understanding is the parties are working through a lease agreement. Matador would like to go ahead and set a contested hearing date for October 27th with the hopes that the parties are able to work things out before then.
The last note, are there any other parties, first of all, Ms. Vance?
Not that I'm aware of, no.
The last note I have from the technical examiner was that you were going to provide an amended CPAC. What happened to that?
For Janie Nelson, I don't think.
Yeah, that's what the note says here. I could be wrong, obviously.
I would have to double check. I don't believe, I think those probably were presented when I was out, if
Okay.
they were presented. So I would have to go back and check. I'm not aware of that.
There's a bunch of notes here from August 3rd.
I would have been out, so
Oh, you're out.
yes.
Was it Mr. Rankin who presented this case then?
Could have been.
Could have been.
I don't think
So many
that
things have
Yeah,
happened
of
between
course.
now and then. I'm gonna have to look at I just don't have it in my head, so I'll have to
Okay,
look.
no problem. I don't mean to put you on the spot, Mr. Rankin.
Do you have a specific case number that that's related to, or is it all of them?
25912, it looks like, 25912, it says it's joined with 3 other cases, but those cases are not on today's docket, it seems. Let me ask Freya. Freya, do you know why I called 4 cases where only 1 was appearing today, but they're joined?
All 4 cases are on today's docket, and it doesn't look like they were heard by affidavit previously. I think maybe the hearing examiner did review the case in preparation for a hearing, but it never went to hearing.
Okay.
And that's
so
what
when-
those notes are.
So when you're saying all 4 cases are on today's docket, this is case number 1 is 25912, but case number 2 is 26147, so I'm not sure.
What?
You're saying the other cases are on today's docket?
They are.
1, 3, what numbers are they on the docket? 1, 3, 1, 4, and 1, 5? Oh, I see. There's number 6 is 1, 3. They're kind of all over the place. I wonder why they didn't. Okay, I see. Okay, they are here. 6, 7, and 8. It looks like. Okay, so back to the business at hand. There are notes in here, but I guess that was in preparation for a hearing by affidavit that never happened, and now we have an objection. So all that's mute, or moot instead of mute. October 27?
Yes, please.
Ms. Tripp, October 27?
Yes, that works for us. Thank you.
All right, now, let me just understand a little bit more about your client. And is it Permian? Is it that's who you represent, Ms. Tripp?
Yes, it's Permian Development LLC.
Development. Okay. Do you anticipate competing applications?
Not at this time. I believe we wanted to reserve or preserve the ability to question any witnesses if possible.
Oh, sure. Do you think that you're going to provide your own witnesses if this goes to a hearing?
I've not been in communication with our client as to that extent. Our hope is that we're able to continue and finalize negotiations.
Okay.
But I will certainly be in contact with Ms. Vance and comply with the rules if we are going to provide a witness.
Of course. Okay, so this objection is really for negotiation purposes. When did you enter your objection?
I believe our objection was entered on August 4th, and it was Mr. Cloutier who was appearing at that time.
Mr. who?
Mr. Cloutier, Drew Cloutier in our firm.
Oh, he's in your firm. I have not heard that name before. Okay. So you objected on August the 4th. Okay. When did you file these cases, Ms. Vance?
We filed on January 7th, so they've been around for a while.
January.
That's what I have in my notes. And yeah, that's correct. Well, because previously there was the objection from Avant and the parties were working through things. I'm not sure, I would have to go back through the case file, how many status conferences may have occurred based off of the Avant objection. But once that was withdrawn, we were going to move forward, and then we had the second objection. So we're sort of at a reset.
I have in my notes, I have the first note is from March. Status conference, parties requesting additional status conference, a motion to continue to 4/16. At 4/16 status conference, parties are negotiating and Avant may file competing applications. If they file, they'll need the July contested hearing. That's what I have. When did you withdraw your objection?
We withdrew our objection on June 29th, and we dismissed our competing applications.
June 29.
Yes.
So, Ms. Vance, why did this case not go to a hearing by affidavit after June 29?
I'm looking, and it appears we filed a continuance. We filed a continuance to the August 6th regular docket. And then after,
objection came.
and then the objection came. So
So, Ms. Tripp, Ms. Tripp, why is your client objecting 8 months after the proposals and the application?
Well, it appears from the pre-hearing exhibits that were filed, there was an amended well proposal sent July 13th. And I believe it's just been a difficulty in communicating or connecting between our client and Matador's land. But I know that they have been in communication since that date. And we're hopeful that we'll reach.
Right. So you're saying that it's because of the amended July exhibit that you objected?
I'm going off of what's apparent in the record right now. I don't have that detail from my client at this point. I'm sorry.
Okay. Ms. Vance, help me out here. Why did you amend your July exhibit, and why would that involve Permian Development LLC?
Well, it wasn't an exhibit. It looks like there was a supplement to the proposals that was sent out on June 10th, and I'm looking to see what the basis of that was.
Okay.
If you'll give me a moment.
Oh, sure. We can come back to this case too, if you prefer.
It won't.
Okay, sure. Take your time.
It looks like it's just updated AFEs, so nothing about like the spacing or well locations changed. It just looks like it was updates to AFEs to reflect current estimated costs for the wells. Okay. Since it looks like that was sent out on June 10th, 2026. The original proposals were sent out on January 9th. So, I'm assuming just because of the time period in between there, they just wanted to make sure that they sent out updated AFEs.
But Ms. Tripp said that you filed an amended exhibit in July. Do you know what she's talking about?
I don't see amended exhibits. I don't want to speak for Ms. Tripp, but I think maybe it's just referring to the updated proposals, not the amended hearing packet itself.
Ms. Tripp?
Yes, I'm just going off of the July 30th exhibits to the pre-hearing statement, which includes correspondence, which is dated July 13th. I do know that based on my review, Permian was in communications with Matador prior to July 13th. However, so I'm trying to piece together that I think communications and negotiations have been ongoing, but certainly more active in the past few weeks or past few months.
Based on the age of this case, these 4 cases, October 27 is too far off for me. So, Fred, what do we have in late September for hearings?
September 15th.
That's the only one?
Correct.
And then in October?
Before the 27th, we have the 20th.
So nothing between September 15 and the 20th of October?
Correct.
What about the hearing by affidavit? What about the hearing by affidavit docket? Is that the 3rd?
September 3rd, yes, we do have a contested hearing already set on that docket.
No, I'm sorry. In October, what is the hearing by affidavit?
It's October 8th.
All right. Ms. Vance, I'll give you a couple of options here, and you check with your client, and please report back by the end of the day. You can have either September 15th or you can have October 8th. And Ms. Tripp, please check with your client as well. These cases have been going on far too long to continue. If this was a June, if this was something filed in May or June, I'd be happy to give you October 27 for another 2 months of negotiation. But at this point, I'm not. So those are your options, Ms. Vance. Would you please check with your client and with Ms. Tripp and get back to Freya by the end of the day? Bless you. So we can file a pre-hearing order.
Yes.
All right. Well, thank you. Anything else, Ms. Tripp?
Nothing else. Thank you. I'll do that.
Anything else, Ms. Vance?
No.
All right, we're off the record in these 4 cases. Okay, number 2 on my docket, I hope this is going to go in the order that was sent out. I don't know anymore. 26147 Matador Production Company. It looks like it's joined with 26148, 49, and 50. That's not what you have, obviously.
No, it's not. I'm not sure.
Okay, I think Freya's going to bring me the docket that she sent out yesterday. I don't know why our hearing module.
Those dismissals.
Yeah, but those were in the middle.
Yeah.
Those were like 20 through, I have a bunch of dismissed cases here.
Yeah.
Okay.
This is double-sided.
That's fine. Thank you very much. I appreciate it. All right. We'll get our act together. I'm going to call now Avant Operating. This is 25996. Looks like it's joined with 260 62 63 64 65 26129 and 30.
Good morning, Mr. Hearing Examiner. Caitlin Luck appearing for Avant.
Morning.
Good morning, Mr. Examiner and everyone. Ben Holiday on behalf of Coterra.
What's, Mr. Holliday, your position?
So this case was originally set for contested hearing at the end of July. The parties reached an agreement the week of the hearing, asked that it be continued to the status conference docket. Current status, as I understand it, is that the negotiations are ongoing. They're making really good progress. There's just a few sticky issues surrounding some marketing agreements and some due diligence, and the parties need more time to work through that. So optimistic that the deal that called off the hearing will consummate, but based on conversations with Ms. Luck and then with Coterra this week, both sides wanted to go ahead and set another contested hearing date just to ensure that if these negotiations break down, we don't continue this even further.
So, Mr. Holliday, you're representing Coterra, right?
Yes, sir.
Okay, and your cases were filed when?
Oh gosh, these cases were filed sometime around the beginning of the year. I'd have to look. The case has been on the docket for a while. Cases.
And Ms. Luck, when did you file your competing cases?
Because of the timing of the wall proposals, I think that the 25996 was filed in March, and then the other 2 cases, 26129 and 26130, were filed later on. I'll confirm the dates.
So your case was the original case, Ms. Luck?
Yes, that's correct, and it was as early as March.
Excuse me. I just wanted to enter
By
our
all means,
appearance.
please go ahead.
Thank you. Jackie McLean with Hardy McLean on behalf of COG Operating, and we are just monitoring.
Thank you, Ms. McLean. Okay, let's see. I'm looking at my notes here. For these
So for
cases, give me.
application days, sorry, I have February 23rd for 25996, and then I have April 15th for the other 2 cases.
All right,
26129 and 26130.
I'm just reading my notes. Thank you, Ms. Luck. So Coterra was going to move forward with a hearing by affidavit. Avant would dismiss its cases. Is that right, Ms. Luck?
I think that had previously been the idea, but unfortunately, as Mr. Holliday just indicated, the deal has not closed yet. And so the parties would like to have this case set for a new contested hearing on October 27th, if possible, so that we can ensure that we have enough time to get the deal closed.
Yeah, okay. No, I'm not going to do October 27. I have it here in my notes. I have status conference 820 is final, so that's the final conference is today. If no resolution is reached, September contested hearing will be set. The only docket we have in September is the 15th, so that's the only date you can have. So I will issue a amended pre-hearing order for September 15 And that will be the final setting for these cases. If you can't proceed on September 15th, you can dismiss your cases and refile them when you're ready, when negotiations are finished. But we can't keep these cases on our docket. Is there anything further, Mr. Holliday?
No, sir. Thank you.
All right. Ms. Luck, is there anything further?
Thank you.
All right. We're off the record in those cases. Let's move on to case numbers 12 and 13 on our docket. This is COG operating 26134, 26135.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of COG Operating.
Good morning.
Good morning, Mr. Examiner. Jordan Kessler with EOG Resources, just monitoring this case.
Thank you, Ms. Kessler.
Good morning, Mr. Examiner. This is James Parra with Beatty Wozniak, representing Permian Resources, which filed an entry and objection.
Good morning, Mr. Parrott. So you did object, okay. Ms. Hardy, were you aware?
Yes, I was aware of the objection.
All right.
And the parties are in discussions, and COG is optimistic regarding an agreement. They're working with Permian Resources. And so we would actually like to set these cases, if possible, on the affidavit docket in October, because we think that'd be sufficient time to reach an agreement.
October 8th?
Yes, that's what we would like to do.
Sure. Mr. Parrott, what do you have to say?
No objection to that, provided that if an agreement is not reached, then we will not be at a contested hearing, excuse me, on that date, which I imagine wouldn't be happening anyways. Pardon me, go. Pardon my throat. Because Permian will need additional time to send elections and file an application.
Okay, so you would contemplate competing applications if negotiations don't go.
That's correct, but like as just stated, we're optimistic that there will be a settlement.
Sure, thank you. Let's see. Looks like you just entered your objection on the 4th?
Yes.
Okay. And these cases were continued from August 6th. Okay. All right. Okay, then Ms. Hardy, it'll be up to you to move your cases to the October 8th hearing by affidavit. And if for some reason you're not successful, then how do you propose to proceed?
I would propose that if Permian Resources objection is not withdrawn by the deadline for us to submit exhibits for the October 8th docket, that we could set the case for a status conference for a contested hearing on the docket after that.
I have another
is
idea.
posted.
Why don't you just file a motion along with, get Mr. Parrott position on it, file a motion to set a contested hearing, pick a date, you can speak with Freya, get dates maybe in November.
Sure.
That way we don't waste a bunch of time at the status conference to do the same thing.
Okay, absolutely.
And that'll keep it off the dockets, and we'll just issue a pre-hearing order once we hear from you by motion. Does that sound fair, Mr. Parrott?
Yes, sir. That's perfect. Thank you.
Okay.
That sounds good. Thank you.
All right. Thank you, Ms. Hardy. Mr. Parrott, we're off the record in those two cases. Let's move on to Matador Production. This looks like we have a few cases joined, 26147, 148, 149, and 150.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, MRC Permian Company, with designating Matador Production Company as the operator. I did just want to put a note that I got a little confused on the last not the last set, but the previous set of cases. And I needed to enter an appearance for.
Which case numbers?
It was case numbers 26062 and 26063.
Okay.
On behalf of MRC Permian Company, in those two cases, and we were just monitoring.
Perfect. Okay, thank you.
And I do have an answer, well, at least for my client on those first set of cases. I'll follow up with Ms. Tripp, but I think she'll agree to the date. Anyway.
What date?
The October date.
October 8th.
Yes.
Freya, was that the date that I offered? Was October 8th? I don't remember anymore.
Yes, that was one of the two options.
I thought it was. All right. So unless we hear from Ms. Tripp in the negative, we'll issue a pre-hearing order for October 8th for those cases.
Understood.
All right. Now back to the cases at hand. So you've entered your appearance for the for Matador Production, or that's the operator you said.
Correct.
Okay. Do we have others?
Mr. Examiner, if I may enter my appearance, Jordan Kessler on behalf of EOG Resources monitoring this case.
Thank you.
And Dana Hardy with Hardy McLean on behalf of BTA Oil Producers LLC. And we did object and have filed a competing application, which is currently set on the September 3rd docket.
September 3rd docket.
Yes.
Okay.
And it's case number 26398.
26398, you said?
Correct.
Thank you. Are there any others? I have a Larson Law.
Yes, this is Derek Larson. Can you hear me, Mr. Hearing Examiner?
We can all hear you, Mr. Larson. Go ahead.
Great, thank you. Entering, representing Bill Taylor, Harvey Taylor, and Marilyn Taylor. There are two other siblings in that family represented by Joe Drennan, who I do not see online at the moment. He entered an appearance, I believe, yesterday in the case that Ms. Hardy, I believe, just referenced. That's 26398, application that overlaps the acreage that Matador is seeking to pool. So they're at least partially competing applications. I just received a copy of that yesterday, and so I would be entering an appearance and an objection in the 26398 matter, insofar as I think that, well, the two applications are going to need to be considered, I think, together or side by side anyway, at least as to the overlapping acreage. Meanwhile, the parties are, our clients are in discussions with both applicants, Matador and BTA, and others in an attempt to lease their interests for the acreage. Our initial objection was the timing on the Matador one, where we had just 5 days of notice. And at that time, it was to be set by affidavit. And this is the four cases that I think you called just now. Ms. Hardy, I did see an email from
Mr. Larson. Mr. Larson, yes. Can you hold on for a second?
Sure.
If you want to discuss something directly with Ms. Hardy, I suggest you do it through email. Sure. In this forum, we called these four cases in July. Was there a reason why you didn't appear?
Yes, sir. And I apologize for that. I was in a hospital in Wisconsin with a medical emergency. Was unable to do much of anything at the time.
Mm-hmm. Okay. All right. So the notes here say that today is the final status conference, that we are setting a contested hearing if the objections have not been resolved, and they obviously have not been. Ms. Hardy has filed a competing application, which is set to be heard and obviously objected to. And I've heard you just object to it as well. And obviously Ms. Vance is objecting to it.
We filed our objection yesterday.
Okay, to 26398.
Yes.
Okay. And Ms. Hardy, can we join 26398 with these four cases?
Yes.
We can. Okay. So we will do that. So we need to set a contested hearing for these cases. I'm going to start with you, Ms. Vance. When?
Well, we would like to do another status conference. But if we have to pick a contested hearing date, then it would be the latest date possible. If not the October, if there was a November date, we would take that.
Okay. The October 27th is the latest date that we're offering at this time. Ms. Hardy, does that work for your client?
I will need to confirm their availability.
Sure. We have the 20th as well.
Okay.
So please choose the 20th or 27th and let us know by the end of the day so we can issue a pre-hearing order.
I will
for
do
these.
that. And I can check, I
Okay.
can probably let you know
Yeah.
by the end of the docket.
By all means. And Ms. Vance, will you check with your client as well?
Yes.
All right, sounds good. Let's see. So Mr. Larson, are you going to participate if we go to a contested hearing?
We will monitor. We don't anticipate any additional testimony, but we absolutely want to ensure that the correlative rights are being considered and protected appropriately.
Okay, all right, that's fair. Okay, attorneys who participate in contested hearings are expected to be here in person.
Certainly.
All right. Ms. Vance, is there anything further on these cases?
No.
All right. And Ms. Vance, when you hear from your client, will you have me recall the cases?
Yes.
All right, thank you. Ms. Hardy?
Nothing else for me.
All
Thank
right,
you.
perfect. Thank you very much. We're off the record in these cases. Let's move on to Permian Resources. There are two cases joined together, 26222, 26223.
Yes, Jackie McLean on behalf of Permian Resources.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating, and we did object to these cases moving forward by affidavit.
And thank you, Ms. Bennett. Are there any other parties that you know of, Ms.?
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of XTO Delaware Basin LLC and XTO Holdings LLC, and we are monitoring only.
All right, thank you, Ms. Vance. Back to you, Ms. Bennett. Is it your client's intention to file competing applications?
They are considering filing competing applications. Right now, the parties are engaged in very productive negotiations. In fact, I heard from Coterra this morning that they had a call with Permian Resources last night, and they're hoping to respond to their trade proposal by the end of the week. But they, if we are moving towards a contested hearing, then they will be sending out competing proposals. Coterra does have a JOA in this area in one of the sections that Permian is proposing to pool, and owns 87.5% of the working interest in that. So they do feel very strongly about their position, but they also are hoping to reach a commercial agreement. So I'm hopeful that we can, that these cases will be dispensed of through trade negotiations, but if not, I understand from Ms. McLean that Permian Resources would like to set a contested hearing date. And I've been coordinating with Ms. McLean this morning about that. And I do have a personal thing in October that would prevent me from being at the October 20th hearing date. So I've asked Ms. McLean if we could do October 27th or even November 17th in case Coterra does need to send out competing proposals. That's the first time those proposals would be right for a hearing.
Thank you, Ms. Bennett. Ms. McLean?
Yes, everything she said is true. I would say that this is the second set of metallic cat applications that we filed. We dismissed them once before so that the parties could engage in negotiations. Coterra has had this in front of them for a really long time, over a year at this point, is my understanding, when the initial proposals went out, and we filed our applications at the beginning of the year for the initial metallic cat. And I think these were actually supposed to be on a April hearing docket, a contested hearing docket, that is. We would like to set a contested hearing in October. I understand Ms. Bennett's issue with the October 20th date. I had gotten that date as the only availability of Permian Resources, but I've sent a text and email. I'm still waiting to hear back. I'm not sure if we can do October 27th. I know that they do not want to go into November because they do think that they can reach an agreement, and they'd like to motivate the parties to actually come to an agreement.
Seems fair. Okay, then why don't we wait for your client to get back to you? Will you let us know by the end of the day?
Yes, I will call when I'm out. I'll do everything I can to get in touch with them.
All right, and then we'll issue a pre-hearing order for October 27 to accommodate Ms. Bennett's schedule as well. Is there anything further?
Nothing from Permian Resources.
Thank you. Ms. Bennett?
Nothing further. Thank you so much.
Perfect. All right. And Ms. Bennett, knowing that we're setting this for October 27, you do still have time to send out proposals and get the applications in. You know, I wonder about this. I still wonder about this 30-day period when parties know that they have competing applications. I don't quite understand the idea behind the 30-day wait period to file an application. I can understand if there's overlapping acreage and then you have different notice issues and maybe other parties want to, I understand that perfectly, but if the acreage is overlapping, anyway, it's just something I think about sometimes. But anyway, Ms. Bennett, the ball's in your court there. So thank you, and we're off the record in those cases. Let's go to number 20 on our docket. It's NSP Resources 26243, but we also have 26244, and I don't see them as joined, so we'll deal with that in just a moment.
Sharon Shaheen on behalf of NSP Resources, and your inclination is correct. At least for today, we should probably join those two cases.
Thank you, Ms.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating. And we did file, we objected to the cases, and we filed competing applications that are set. Well, I filed them for the 9/3 hearing date, and now they've been set for a status conference on 9/17. And those are case numbers 26415 and 26416.
Okay.
And I've been in discussions with Ms. Shaheen this morning about next steps, in case you're interested in hearing from me or Ms. Shaheen.
You're still
Okay.
talking, so go ahead. We'll go back to Ms. Shaheen in a moment.
So Ms. Shaheen and I were conferring yesterday and this morning that the parties again are engaged in productive negotiations, and Ms. Shaheen in fact had to file amended applications yesterday. So those will also be for the October 8th docket. So what we were hoping to do is, I know in the hearing transcript it did say that this was a final status conference today, but given these moving parts, including the filing of the new amended applications, we were hoping that Ms. Shaheen's cases could be consolidated with the competing Coterra cases for an additional status conference on September 17th to allow the parties additional time to negotiate, and then at that time set a contested hearing.
I can do part of what you want, but I still want to set a contested hearing. That's the whole point of saying that this today is the last status conference. I mean, we'll set a contested hearing. Does October work for, I know the 20th doesn't work for you, but does the 27th work for you?
The 27th does, I mean, it does, because I proposed that for the other hearing, and you'll be probably hearing me say that again later. I understand that Ms. Shaheen also has another contested hearing on October 27th, so I'm really, if we do set this one for October 27th, it's going to be lots of fingers crossed that they go away. But
isn't that always the way it is?
Yes.
So, I mean, okay, that sounds great. Ms. Shaheen, why did you file amended or are filing amended applications?
They proposed additional wells.
Oh, okay. I see. In the same acreage?
In the same acreage that was originally proposed.
Okay. All right. And when did you file the original cases?
June 9th.
Perfect. Appreciate that information at the fingertips. Okay, so Ms. Shaheen, October 27th?
Yes. We'll keep our fingers crossed.
Of course, and we'll join them to 26415 and 16. Is there anything else you want me to know, Ms.
Well, I'll just have to give you the new case numbers. I don't believe I have those yet.
Oh, they'll have whole new case numbers. Okay.
I don't know of a process that would allow us to keep the old case numbers. If there is one, I would certainly like to know about it.
So basically, the application is for the same acreage, but it's more wells. It's a different configuration of wells. And that requires, help me understand why we need a new case number.
In the past, prior to
Yes.
filing through OGRID,
Yes.
there was no need for a new case number. But for some reason, I understand some technical reason, when we file an amended application, it automatically triggers a new case number. That's my understanding.
I see.
I'm not a tech person.
Yeah. Ms. Bennett, do you know?
That is accurate, that if you file an amended application, then it does automatically generate a new case number. But I also am aware of circumstances when the division has been willing to work with parties to substitute an amended application for an existing application to keep the same case number. My experience with that has been before the docket is sent out, though, because that occurs, like, let's say I filed a case on Monday and realized on Tuesday that I had messed it all up, then Freya hasn't already sent out the docket, so it's no big deal to just swap out. But I do think there is a behind-the-scenes administrative process that if the division were willing to consider would allow parties to keep the same case numbers. It does impact the division's bottom line, of course, because we pay $500 every time we file a new application. But there is an administrative process that could be workable and I think would streamline the whole hearing process if we were able to not get a new case number every time we needed to file an amendment to an application.
I'll ask you in just a moment, Ms. Vance. I want to finish, and I appreciate the help that you're going to give me, so thank you. But when it comes to notice to parties, I guess that's what I'm wondering about in the background. I mean, I understand that we can do things administratively with IT, et cetera, but when it comes to noticing parties, now this amended application will be sent out. Will it be renoticed to everyone?
Because it has new case numbers, yes.
But because it has new case numbers.
That was my thought, but we've also sent out supplemental well proposals to provide notice to everyone that we're proposing additional wells and give them an opportunity to elect or to voluntarily participate. So yes, I am planning on sending out new notice.
Ms. Vance?
All I was going to say is we, Holland and Hart, have filed amended applications under the same case number. And typically what we'll do is we reach out to Freya and I just let her know, and then we'll coordinate redoing the public notice. That way we can keep the same case number. And sometimes I've reached out to like whoever the technical examiner is, just to make sure that they agree to that, and it's not going to be an issue for the division. So
and back to what you were just saying. So you see the benefit in keeping the original case number?
Yes.
What is the benefit?
I mean, for us, it's just not having to go just keeping the continuity of having the same case and managing just one case number. So it doesn't get either confusing on our side or for who we may have already sent notice out to. Because if we have to follow up with new notice, they can just see it's the same exact case. And if they're monitoring through the division's through the division's portal, they know to just consistently look for that same case number.
Thank you. Ms. Bennett?
Thanks. I just wanted to clarify, though, that I do believe, like Ms. Vance was saying, when there are changes to applications, even if it's the same case number, additional notice does need to, on our end, needs to occur.
And it sounds like Ms. Shaheen is doing that new notice.
That's correct.
But would like to try to find a way to keep the original case number if possible and save her client $1,000 or so. So Freya, what can you tell me about what you've heard?
All of those options are options. What I've done in the past is if an applicant wants to file an amended application, they can file it under the existing case number as a motion and then contact me with the new language that needs to be noticed, and I will manually add it to the next hearing by affidavit docket notice,
I see.
if that makes sense.
It does make sense. So you still have to provide new notice, as does the applicant. Interesting. But you're able to keep the same case number. Well, Ms. Shaheen, that seems like the way to go here. I mean, it helps your client and it helps you by keeping the same case number, and it keeps the confusion factor down. I realize that it takes money away from the division, but I mean, I think in this case that makes sense.
It is. I will confer with Ms. Chance.
Okay, perfect.
About, because I think they've already been accepted for filing. So I'll confer with her about how to fix it.
Okay.
Great. Thank you for that.
Yes, of course. Okay. Ms. Shaheen, anything further on this? Because we're going to issue a pre-hearing order for October 27 if we don't hear from you by the end of the day telling us that you just can't do that for some reason.
Okay.
Okay. All right. And Ms. Vance, same thing.
On what? I'm not in this case.
Ms. Bennett, I'm sorry.
Thank
You've been talking in this case, so I thought you were involved. Ms. Bennett, same thing. We'll issue a pre-hearing order by the end of the day.
Thanks.
All right, you're welcome. Let's move on to case number 22. This is XTO Energy 26248.
Good morning, Mr. Examiner. This is James Parrott with Beatty and Wozniak representing the applicant XTO.
Thank you, Mr. Parrott.
Sharon Shaheen on behalf of Pride Energy.
Thank you. Oh, Ms. Shaheen, you're up.
And yes, we've objected to this going forward by affidavit.
Right, you've objected and you intend to file competing applications?
This is a different type of application. It's not a compulsory pooling application,
Okay.
so there's no
I see.
competing proposals.
Okay, all right, thank you.
Good morning, Mr. Hearing Examiner. Darren Savage with Aberdeen Shield, appearing on behalf of Devon Energy Production Company, LP, and appearing on behalf of VF Petroleum Incorporated. Devon is only monitoring and preserving rights. However, VF Petroleum has objected to this application.
All right, perfect, thank you. All right, Mr. Parrott, how do you want to proceed?
Thank you, Mr. Examiner. I believe that the Pride Energy objection is on the precipice of resolution.
Okay.
Perhaps Ms. Sheen can add some color to that. We sent an update yesterday afternoon or yesterday during the day. Haven't heard a response yet, but it's a pretty new bit of information. As far as VF's objection, XTO believes that there's really no merit to the objection as the application does not have any impact on VF's interests. I can provide you with a screen share of the application and explain a little bit more why if that's your pleasure. But in any case, we'd ask that the application be set for hearing at the earliest possible opportunity. Don't believe that there's really anything that's needed for a long run-up or negotiations to resolution. Thank you.
Okay, Mr. Savage, do you know what the nature of the VF Petroleum objection is?
Yes, I can explain that.
Go ahead, please.
Okay. So this application basically is revoking the rights of owners to object to non-standard spacing units.
Wait, this is an application to revoke the objection?
Yeah, it's basic. It's a very unusual application. So it deals with a large federal unit, the Big Eddy unit, and so when an operator gets the privilege of having been granted a federal unit, they get lots of benefits. They get lots of flexibility in there. But there's an area around, and because the unit is developed by ownership, there's a lot of irregular shapes around the border. Okay, so where the border areas interface between the members of the federal unit and the owners on the outside of the unit.
Sure.
And that's really where the issue of correlative rights come into play, because those adjoining units, they're adjoining tracts, they're going to be part of these irregular shaped of units. So currently under the rules, and the rules were adjudicated, I believe, in 2018.
Are these the federal rules or are these the state
are the
rules?
the OCD rules. These are Title 19, what is it, Title 19, Chapter 15, Part 16. So they're, this is in 2008, they applied the rules to the horizontal wells and the statutes, and they didn't really amend the statutes, but they adapted morphed the rules. So those were done under proper rulemaking procedures. So what to me, and I talked to Jacob, Mr. Everhart, about this. So what the case does is it says, okay, we're going to have at the border we have an irregular section, but we want to deem it to be standard, and we want the irregular shape, the non-rectangular shape, which would otherwise be non-standard. We want it to be only within the federal unit, the federal exploratory unit, and not include any tracks that would make it standard outside any adjoining tracks. So basically, and then we want to do this across the board as a blanket application without looking at where the wells would be and proposing to the OCD an actual spacing plan.
And how does that affect your client, VF Petroleum?
So our client is entitled to notice because we have an offset ownership of a tract. So we're entitled to notice, and we're making an appearance, and we made an objection. Our main concern about this is the revocation across the board of the right to object and to protect correlative rights, because what we think this case may very likely do is set a precedent that once this is granted, then it would be a precedent. There would be no reason for another operator of a federal unit to ask the same thing. And basically, it's kind of a backdoor way to get around the established rules, and we're concerned about that. And we would like opportunity if the OCD may agree that this is a direction they want to go, and if they do, they should hear all the concerns and arguments and cross-examination and all that.
But your client is in negotiations to what? Make that go away?
No, our client. I mean, if we believe there's other options besides approaching it this way and doing away with the rules.
So you might convince Mr. Parrott to withdraw the objection, to withdraw the application.
Withdraw the application and then approach it from a different way. And I have some ideas that I'd be glad to discuss. So.
All right, perfect. That's great. Thank you.
Thank you.
I appreciate that, Mr. Savage. Mr. Parrott, do you want to add anything to that?
Yes, please. I appreciate the opportunity to respond. Just to clarify exactly what the application says, would it be okay if I do a screen share of the application? Okay.
Go ahead. It sounds novel that everyone would want to see it.
Thank you. Okay, Freya, this is the application.
Freya, while he's sharing this with us, can you figure out why Mr. Larson has his hand up?
I think that was a previous hand raise. I don't know if it's still, he just put it down.
Thank you, Freya. Okay, go ahead, Mr. Parrott. I'm sorry to interrupt you.
Okay, yeah, thank you very much. So this is the application itself. This was filed with the division on June 8th. It's been public record for over 2 months now. The application is, as you can see, the highlighted paragraph is really kind of the key request in the application. And it requests that standard horizontal spacing units within the FEU be allowed to align with the boundaries of the FEU, of the Federal Exploratory Unit. And just to show you exactly why we're asking for that, I'm going to click over to Exhibit A1 in the application. So as you can see, it's a very irregular boundary, as is fairly typical with FEUs. There are many areas of the FEU where the boundaries align with quarter sections and sometimes quarter sections. This makes it very difficult to establish spacing units that align with the boundaries and of the unit. The alternatives would be to sort of one by one establish non-standard units, which, as everybody knows, tend to elicit objections and slow down development. or to do straddle units that overlap the boundaries of the unit. And for many, many reasons, those are very problematic. So XTO is asked to be able to establish standard spacing units that align with the boundaries of the federal exploratory unit. There's no attempt to thwart any kind of notice or opportunity. We have noticed every single owner, including overriding royalty interest owners adjacent to the unit and within the unit. It was a huge notice list to ensure that everybody's due process rights are protected. There's no attempt to revoke anybody's rights. That's a complete mischaracterization of the application. Everybody now has an opportunity to participate and raise any objections.
Okay, Mr. Parrott, I understand, Mr. Parrott. Thank you. This has been helpful.
May I add?
Well, hold on one
Chairman.
second. To the best of your knowledge, has the division ever granted an application such as this?
No, I believe this is a novel approach to deal with federal exploratory units in the state.
Okay, all right. I have all the information I think I need. I'm not going to be the technical examiner, thankfully, for this case. And so when do you want to set it for?
As early as possible. September would be ideal. Thank you.
All right, September 15?
That would be fantastic.
All right, so Mr. Savage, we're going to set this case for a contested hearing on September 15th. Do you anticipate, if you don't negotiate your way out of this, your objection, do you anticipate bringing witnesses?
Yeah, I think one witness, perhaps the landman.
The landman?
Yeah, I think provide some commentary.
Fine. Okay.
May I?
May who?
On behalf of Pride.
Ms. Shaheen, are you entered on this case?
Yes, I
You are.
enter
Okay,
my
yes,
appearance on behalf of Pride Energy.
Go right ahead.
And so I would like to say, we have been conferring, Pride has been conferring with XTO. However, we are not close to an agreement.
Okay.
We, in short, let me look at my notes here.
Okay.
Pride has an offset interest in Section 35, Township 22 South, Range 29 East. And if XTO were to decide to use this, an order approving this application to create to deem a non-standard unit a standard unit, Pride needs to be included in any development of Section 35. And in part, that's because there are limited drilling islands there. We need something in writing from XTO that commits to including Pride in any development in Section 35, and we have not been able to come to that agreement. As for September 15th, I'm going to need to check with my client because that is earlier than we anticipated. I was looking at the October 20th and October 27th dates.
Well, talk to your client, let us know. But if we don't hear from you, we'll issue a pre-hearing order for September 15th, and we can always continue it. If we start on that day and your client needs to go another day, we can continue it to another day. But at least we'll get the process moving. Mr. Parrott, anything further?
No, thank you, Mr. Examiner.
Ms. Shaheen?
Not for me, thank you.
Mr. Savage?
Thank you.
Okay, excellent. We're off the record. All right, let's go on to Longfellow Energy, number 23 on our docket. This is 26252.
Good morning, Mr. Examiner. Miguel Suazo with Beatty & Wozniak, appearing today on behalf of the applicant, Longfellow Energy.
Good morning, Mr. Suazo.
Good morning, Mr. Examiner. Jordan Kessler on behalf of EOG Resources monitoring this case.
Thank you, Ms. Kessler.
Good morning, Mr. Examiner. Adam Rankin with the Santa Fe Office of Holland Hart, appearing on behalf of SPUR.
You must have objected.
We did.
Okay, tell us about that.
Thank you, Mr. Hearing Examiner. Just in short, this is a new development proposed by Longfellow that's near to the acreage that is currently in dispute between the two parties. And so we are, SPUR was in discussions with Longfellow trying to reach global resolution for all of their issues. We were very
There are many issues.
We were very close, as you'll hear later, very close to reaching a global resolution. However, the parties were unable, that would have resolved this case and the other.
Right.
Unfortunately, were unable to do so. So because of that, SPUR has issued a competing well proposal I believe just yesterday or the day before. And we'll be filing very soon, shorter than the 30 days, an application for competing well development that will partially overlap the Almond case.
Okay.
And so, we understand the division's interest in moving this along and that this has been on the docket for a little bit of time. So we will get one filed quickly. However, given the requirement to have, 30 days prior to statutory and regulatory requirement to have 30 days from the time you file to the hearing date, this won't be ripe until at least October.
Right.
And so I remain, I'm not going to say there's a potential. It sounds like there's some critical issues that would prevent resolution that neither party can really do much about. But, there's always the potential. So if we have this into early November, I think there's a possibility that, remains a possibility. But, so I would ask for, depending on what Mr. Suazo requests, I would ask for a date in the November timeframe so that we can have the other additional parties, because we're going to have a competing case with additional acreage. And I think Spur would like to have some time to try to have make those initial negotiations, even though we're going to file the application sooner than is under the division guidance, that we can have a little bit of time to get that all sorted out.
Okay, let's go to Mr. Suazo. Mr. Suazo, when did you file this case?
Let me look at the date.
Sure.
It was filed on June 9th.
June 9th. Okay, perfect. So, Mr. Suazo, would you remind me of something? We have a Spur application that's coming to a contested hearing soon. When is that? Do you know?
Right now, I believe it's scheduled for September 1st.
Oh, September 1st. Okay. Okay. So I realize that there's some bad blood between Spur and Longfellow. That goes without saying. And Ms. Suazo, how do you want to proceed with your case?
Well, Longfellow prefers to proceed to a contested hearing as quickly as possible. Mr. Rankin's correct that the parties, did give a, pretty significant effort to reach an agreement, but unfortunately those discussions fell apart, and Longfellow is not optimistic that they're actually going to be able to reach any sort of agreement. And if you recall, we last appeared before you on this at the July 23rd hearing. And at that time, Mr. Rankin represented that Spur was going to submit competing well proposals within 7 to 10 days. So it's news to me that that they're going to submit proposals now, when in our estimation they should have been submitting those much sooner. And so this is just another delay, and we'd like to get this moving because Longfellow has made significant progress. The division has approved the 5H well, which is part of this development. They've also approved 4 other vertical wells as part of this development. And so we're moving along. And these delays, when there's been ample opportunity for Spur to make progress, I think is prejudicial to Longfellow. And we'd like to keep this at a contested hearing date sooner rather than later.
Okay, Mr. Suazo. And Mr. Rankin, I do see in my notes that on July 23rd, what Mr. Suazo said was correct, that you did represent. Okay, hold on a second. Yeah. And then you can have your say. That what Mr. Suazo said is correct, that you did say competing applications would be sent out in the next few days, and that we would set a contested hearing at this setting. So what were you going to say?
Yeah, I appreciate that, and that is correct, and they had one ready to go. However, the parties did reach an agreement in principle. There was an expectation that they would be able to close on it. And rather than upset the apple cart by submitting competing well proposals in the midst of that, they held off with the expectation that they would reach an agreement and finalize it. However, as I mentioned, there were facts that essentially foreclosed the ability to do that, unfortunately, for both sides. That being said, given that is the case, immediately following notification from Longfellow that the agreement could not be finalized, we issued the well proposals, or Spur did. So that has been done immediately upon confirmation that the agreement couldn't be consummated. So that's been done. as soon as I get those well proposals, we'll turn them into applications. So we're really not trying to hold or delay this.
I take you at your word, Mr. Rankin. So not to interrupt you, but Mr. Rankin, I'd like to get this set for a late October date. And it seems to me you have time to get your applications in so that they're noticed for the October 8th docket, and then we have a contested hearing set. So would you check with your client and find out whether October 20 or 27 works better? And Mr. Suazo, do the same, please. I figure you want the October 20th, but I'm really going to leave it open to both parties to figure this out. So can you let us know by the end of the day, Mr. Rankin?
Yes.
Okay, very good. All right, so Mr. Suazo, I'm trying to move these cases along and still give due process to Spur as well. Is there anything further?
No, Mr. Examiner.
All right. Okay. Anything else, Mr. Rankin?
Not on this now separate matter, no.
Okay, thank you. All right, thank you both. We're off the record in that case. Let's move on to NSP Resources. We have two cases here. They're not linked, not sure why. This is 26286 and 87. Entries, please.
Good morning, Mr. Examiner. Jacob Everhart with Beatty Wozniak, New Mexico, appearing on behalf of the applicant North Star Resources.
Good morning, Mr. Everhart. Should these be joined?
They're separate.
They should not be joined. Okay, but for today's status conference, we can talk about them together?
They're separate applications with separate kind of parties involved, so I'd prefer to keep them separate.
Okay, then I'll only call the first one, 26286. Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2, and we did file an objection to this case and are objecting to it proceeding by affidavit.
And your intention going down the road is?
The parties are in discussions, and hopefully those will mature into a commercial resolution. But in the event that they don't, Avant is considering sending out competing proposals. And so I understand from my coordination with NSP's counsel today that they want to set a contested hearing. And Avant's not going to stand in the way of that, but there are some timing considerations that I'd like to talk about.
By all means. Let's hear first. Do we have someone from Holland and Hart?
Yes. Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Mewburn Oil Company, and we are just monitoring.
Thank you, Ms. Vance. Mr. Everhart, how do you want to proceed?
Yeah, so in the interest of the client, we like to, this application is part of a suite of other applications that we'll talk about in the docket. That really, it's part of a broader development plan with spud dates this fall. So ideally, we'd like to get on the docket for a contested hearing as soon as practicable. Granted, this application was filed, it's of newer vintage, on June 9th, so it's not old per se, but we like to hold some space. It sounds like the September and the early October dockets are getting pretty full, but we'd like to ask for a contested hearing as soon as possible.
Okay. Ms. Bennett.
Thank you. As I mentioned, Avant is considering sending out competing proposals, and if that, which they're considering right now, we would know in the next week or two if they're going to do that. And again, that's just to preserve their rights if we do need to move forward with the contested hearing. So Avant's preference would be November 17th. And that's in part to allow their proposals to ripen and file the competing applications, but also given my schedule in October, my partner, Michael, is having surgery, and I don't want to have to choose between being at home and hearing prep, just to be quite honest. So I appreciate the division's consideration of my schedule in October. So, I mean, Avant, worst case scenario, we could say October 27th, but that is getting very full with cases for myself and others. So again, my Avant's preference and my preference, for whatever it's worth, is November 17th.
Freya, do we have anything between October 27 and November 17?
Oh. We had the hearing by affidavit docket on November 5th, and I just noticed that the hearing examiner will be out of the office November 10th through the 17th.
Yes.
So I misspoke when I offered November 17th to Ms. Bennett.
Okay, so November 17 is not a possibility. Right. You said,
Mr. Examiner, we would prefer the 27th of October if that's an option.
I see. Ms. Bennett's already involved in 2 cases on that docket, by my recollection. Am I wrong about that, Ms. Bennett?
No, I thought it was 3. Sorry.
Oh,
I thought it
you
was 3,
Well,
but
maybe
I'm.
it is. Maybe it is.
It's definitely 2.
It's at least
I'm-
2.
at
if
least
not
2.
3.
Mhm.
So, Mr. Everhard, I'm all in favor of moving cases along, as you obviously know by now. But I have to be fair as well. I'm looking for another date. Now, you said November, what was the hearing by affidavit docket?
The 5th.
So why couldn't we do the 3rd on the Tuesday before?
We could do that date.
We could do the November 3rd. Mr. Everhard, I think November 3rd is probably the earliest date that we can give you for this case. So would you check with your client?
Yes, sir.
And Ms. Bennett, would you check with your client?
I will.
And we'll issue a pre-hearing order for November 3rd unless we hear otherwise from the parties. Anything further, Mr. Everhard?
Nothing further.
All right.
Thank you, Mr.
All right,
Hearing
thank you.
Examiner.
All right, I'm going to call another one of your cases, NSP Resources 26287.
Yeah, Mr. Examiner, Jacob Everhart with Beatty Wozniak, New Mexico, appearing on behalf of applicant North Star Resources in case 26287.
All right, thank you.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Permian Resources Operating LLC, who is objecting, MRC Permian Company and MRC Delaware Resources LLC, who are objecting, and then Mewburn Oil Company, we're on behalf of Mewburn, we're just monitoring. And I will just go ahead and give a little bit.
Thank you. Yes, go ahead.
Oh,
Thank you.
okay.
Yeah.
Sorry. So both Permian and Matador are going to plan on filing applications, which presents a little bit of a complication for us regarding conflicts. And so, you know, I did speak or had some email go back and forth with Mr. Everhart and his colleague, Mr. Suazo. Our preference would be to have another status conference. My understanding is at the previous status conference, this would be the last one. But given the fact that there are now going to be 2 additional applicants, competing applications in these, that shifts the dynamics. We would ask for the latest possible hearing date in these, you know, considering the different moving parts involved. So that would be our request.
So you're saying that you're going to file competing applications. Where is that? Where are you in the process?
So with Permian, we'll be filing those pretty soon. I would say maybe in the next week or so. With Matador, I know the counter proposals have gone out, but I need to check in to see what the timing of those were to understand better when that will be ripe for filing the applications. So again, I would just push to say that considering the timing, a later October 27th contested hearing date.
But Ms. Vance, what I'm wondering is, who's going to represent one of the parties?
That's what we're working on right now.
Someone in-house?
No, we're trying to,
Okay.
without going into details, we're working on that right now, so.
Okay, thank you. Did we have anyone for Avant?
Yes, good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2, and we're monitoring the case to preserve Avant's rights.
Thank you, Ms. Bennett. Mr. Everhard, you've heard some of the wrinkles here. How do you want to proceed?
Yeah, so I guess just thinking about our prior status conference on the 23rd of July, parties, North Star and Permian, had trade and agreement discussions after that status conference. Really didn't yield any concrete outcomes or solutions. I think all parties have had more than ample sufficient time to prepare for these, as in terms of getting competing applications on the docket. So we would at this time ask for the soonest available contested hearing. This is a cornerstone application of some fall development. They're rig scheduled. Priority with rig availability, as you know, is sometimes comes into issue. Agreements have been signed. So we're gearing up for a busy fall, but we would like this sooner than later. So I would propose either September 15th or October 20th.
It seems based on what Ms. Vance is telling me about the applications being filed soon, they wouldn't be noticed until early October. So the earliest we would be able to do is sometime in October. We have the 20th and 27th. 27th is pretty busy now. We possibly could do October 20th. And I know that you would like to do October 20th. So what I'll say is, please work with Ms. Vance. I'll offer you October 20 for now. However, depending on Ms. Vance and her client, we may not be able to do until November 3rd, but that would be the latest I would.
Understood. And we will work with,
Please.
the parties involved, and I'll work with Mr.
Perfect.
Everhart and provide an update to the division as soon as possible.
By the end of the day. So please let
Understood.
the division know by the end of the day, or else we'll just do October 20th in deference to Mr. Everhart's wish. So we'll look forward to hearing from the parties. Thank you.
Thank you.
All right, we're off the record in those two cases. Let's move on to Matador Production. We have 3 cases joined. 262899093.
Sorry, give me 1 second. I was writing some notes from the previous, I believe. Which ones were those? Betty Jones. All right. Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, MRC Permian Company, and Matador Production Company as the designated operator.
Thank you.
Jackie McLean on behalf of Marathon Oil Permian.
Thank you.
And we objected to these cases.
And what is your intention moving forward?
We have spoken with Matador's counsel, and I believe both parties have requested another status conference on September 19th. We are negotiating and we're hopeful. And we thought that another status conference would serve the parties.
In other words, next month?
Yes.
September 19, you said?
I believe that's the date.
Freya, is that the date?
It's the 17th.
Oh, sorry, 17th.
The 17th. So the final status conference will be September 17. Does that work for you, Ms. Vance?
Yes, we agree with that.
And do we have another party, or are those all the parties?
I believe that's it.
That's it? Just you 2 parties? All right. Now, Ms. McLean, you didn't mention, when I said what's your intention, I realize you're negotiating, but is it your client's intention to send out well proposals if?
I am not sure at this time, but we would know by that status conference.
All right, okay. All right, that'll be the final status conference. So I'm just letting the parties know now. So Ms. McLean, if knowing that it's the final status conference and knowing we'll probably set it for a November contested hearing, please think about when you're going to get your applications filed so that they're mature for a November
We will do that.
hearing. Thank you. Anything further, Ms. Vance?
No.
Very good. Okay, we're off the record in those 3 cases. Back to an NSP case. This is 26310.
Yeah, Jacob Everhart with Beatty Wozniak, appearing on behalf of applicant North Star Resources.
Thank you. Who's representing Mewbourne?
Oh, good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Mewbourne Oil Company. And we did object to these cases moving forward. We filed a competing application on August 4th, and that application is case 26418.
26418?
Yes, 26418.
So can we join the 2 cases?
Sure. I'm not sure, Mr. Everhart, if they have filed an entry of appearance or objection in that yet. There is a partial overlap in these. And I will say, Mr. Everhart, actually, we did talk on this one, and I believe we both agreed to request another status conference on September 17th.
Okay. Mr. Everhart.
I think the additional status conference were for more applications kind of down the line in the docket for the Tin Goose and the 4Fan. I think on this particular application, we intend to file entries of appearances and objections to the competing Mewbourne cases. But as it relates to the North Star case, they are an overwhelming working interest owner with a high percentage of the working interest owners already joined. And as Ms. Vance has kind of alluded to, discussions have been semi-fruitful, but nothing concrete yet. So with that kind of in mind, and the fact that anticipated SPUD is November and APDs have been filed for North Star, we are pursuing the soonest available contested hearing. And I would propose October 20th in the event that the previous North Star case gets pushed to November 3rd.
Okay, Mr. Everhard. We'll grant that. We'll issue a pre-hearing order for October 20th, and then we'll expect that you will continue this case to a status conference in September so we can find out how the parties are proceeding. And we will join, Freya, we will join 26418 with 26310 as they are competing and overlapping. Ms. Vance, anything further?
Yes, two things. One, just want to confirm that we need to go ahead and file a continuance for our case.
Yes.
Okay. And then
Wait, hold on. Your case is, you said, already set, isn't it, for hearing by affidavit document?
Yes.
You don't have to pay for that. We'll move it for you.
Okay.
Because it's going to be objected to. We do that complimentary. So we'll move it to the September 17, I think we said, status conference docket.
Yes.
Joined with Mr. Everhard's case, but of course, you'll have to move that case yourself, Mr. Everhard.
Yes, sir.
But I'm sorry, go ahead, Ms. Vance.
And the other, I need to confirm with my client that they would be available for an October 20th.
Well, hopefully they will be. Thank you. All right, off the record in that case, let's move on to Devon Energy Production, 26316, 26317.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Devon Energy Production.
Thank you.
Mr. Examiner, Jordan Kessler from EOG Resources on behalf of EOG and just monitoring this case.
Thank you, Ms. Kessler.
Sharon Shaheen on behalf of Alpha AEP2 Operating and also on behalf of Paloma Permian Asset Company. And I believe that both parties have objected to this going forward by affidavit.
Okay, what are your client's intentions?
With respect to Paloma, there are pending applications in case numbers 26321 and 26322.
Okay, wait, you went a little
competing.
fast for me. Hold on a second. You said regarding Paloma, we have competing applications?
Yes, they're on the docket numbers 32 and 33.
Okay, can you give me the numbers again?
26321 and 26322.
Okay, but they're not joined with this case?
They haven't been joined yet, but they should be.
I understand. Okay, so we have competing cases 26321 and 22. So why don't I call those cases along with the Devon cases? I am going to call those cases 26321, 26322, and we'll get entries of appearance for those cases in a moment. You were just going through your competing applications to the cases I called originally. And then what about your other client, AEP2?
They've objected, but they will not be filing competing proposals.
Okay, all right. Okay, do we have someone from Beatty and Wozniak?
Yes, Mr. Examiner. Good morning. Miguel Suazo with Beatty and Wozniak, appearing on behalf of XTO Energy.
Your client's position, please.
Well, it depends on which case. So in the Devon cases, XTO Energy supports Devon's application. And with respect to the Paloma applications that you just called along with this matter, XTO opposes their applications.
Okay, very good. So you entered an appearance in the two Devon cases to basically endorse their proposal?
Correct.
Oh, I didn't, okay. I've not, is that commonly done, Mr. Suazo?
We've done it before, but it's not particularly common, I suppose.
Okay, all right. Well, I hadn't seen that before. That's why I'm asking. Okay, so you're in support of Devon and you're anti-Paloma. All right. Okay, so let's see. So Ms. Shaheen, it looks like you are the only objectors to the Devon cases. Is that your understanding, Ms. Hardy?
Yes, that's correct.
Oh, good. And did you know about the competing, you did know about them?
Yes, and we objected on behalf of Devon to
course.
Paloma's 2 applications.
Of course you did. All right. So let me get entries of appearance for 263, 21, and 22. Go right ahead, Ms. Shaheen.
Sharon Shaheen on behalf of Paloma Permian Asset Company.
Thank you.
Dana Hardy on behalf of Devon Energy Production.
Thank you. And then we already heard from Mr. Suazo objecting to XTO. Mr. Suazo, are you thinking of filing some sort of competing application to XTO? I'm sorry, to Paloma?
The client, I don't think has made a decision on that at this point. We're objecting to Paloma's unit because it crosses the Big Eddy federal unit, which we dealt with earlier in the docket. It crosses the boundary line, whereas Devon's competing application does not. So that's why we're concerned about Paloma's application. I would need to check with the client if they might intend to file a competing application, but no decision has been made.
Very good. I understand. Thank you. Let's start with Ms. Shaheen. Let's start with Ms. Hardy, because I called your cases first. Ms. Hardy, how do you want to proceed?
Mr. Examiner, I've consulted with Ms. Shaheen, and we would propose to set a contested hearing on October 27th.
October 27th. Okay. So we'll issue a pre-hearing order for October 27 for these 4 cases: 26316, 26317, 26321, and 26322. Is there anything else, Ms. Hardy?
No, thank you.
Ms. Shaheen, is there anything else?
I would just, Mr. Suazo mentioned that our proposed unit crosses over into the Big Eddy unit. That's not my understanding. We actually proposed a non-standard unit because it's on the boundary. So I'll confer with Mr. Suazo about that and get that cleared up.
Yeah, sounds like maybe you can get rid of one objection. Bless you. Okay, so if there's nothing else, Mr. Suazo, is there anything else?
No, Mr. Hearing Examiner.
All right, thank you. We're off the record in those 4 cases. Let's move on to Longfellow Energy. And we're back to Longfellow Spur. 26328. Entries of appearance, please.
Yes, Mr. Examiner. Miguel Suazo with Beatty and Wozniak appearing on behalf of the applicant Longfellow Energy.
Okay, thank you.
Adam Rankin with the Santa Fe Office of Holland and Hart appearing on behalf of Spur Energy Partners. What else? Where are we?
Is this just a benevolent entry of appearance,
Oh, no.
or did you have some purpose to it?
No, this is, I'm sorry, which case number are we on? Because I want to make sure it's their file. Okay. This is their application to extend the deadline for their petty case, yes.
It's an amendment case, yes.
Yeah, we're objecting to this case.
On what grounds?
On the grounds that, on the grounds that they're seeking an extension, and we want to know exactly what their plans are, and they haven't told us what their plans are. And this relates to our separate application to reopen the same pooling order.
Right.
So those are the same the bases that we raised in that application are the reasons we're objecting to this case now.
I'm confused by that, so help me understand. So your objection to their other compulsory pooling order, which is not up for an amendment.
It is. That's this amendment.
Oh, it is.
They have now, after we have asked them to file an application to amend, and they didn't want to do it, we filed an application to ourselves reopen to amend. They have now, and now it's been set for a contested hearing. Now they have filed an application to amend themselves.
Okay, all right. Let me go back to Mrs. Suazo for a minute. Mrs. Suazo, I wasn't aware that order was coming due.
So the deadline under the order, which was issued last December, is coming up this coming December. And so for this application, we're looking to amend the order, but I think I'd also like to point out that we've filed another application to extend this matter for a year. And so I think I spoke to Mr. Rankin yesterday. I think some sort of consolidation is in order. Obviously, the discussions, negotiations fell apart And this is scheduled for a contested hearing on September 1st with pre-hearing statements and exhibits due next week. So we'd like to, stick to that and get this resolved. But I think, since there's a lot of overlapping issues across the applications, some sort of consolidation is probably proper, but we can talk through that, I suppose.
So typically, I thought most operators file an application to amend, and you're talking about an amend as to an extension of time? Is that specifically what you're talking about?
So for the amendment, we would like to propose a development plan. And for the extension, we just want to preserve the ability for the order to stay in force and effect going into next year.
Okay. All right, interesting. So you're asking for a development plan change. Okay, that's interesting. Typically, the extension of time is like what? The month before is typically when the application is filed?
Typically, so we're ahead of the game, I suppose.
You're way ahead of the game. But I guess with your proposal of a development plan change, that does throw an interesting wrinkle into this. So you're asking to consolidate this case with another case?
So I think the application 25572 can be consolidated with SPURS 26288, and then the extension case, which is not on this docket, 26328. And just to be clear, by development plan, we're not talking about any sort of major change. We're just talking about drilling the wells that are proposed next year versus this year.
I see. Okay, I understand. I'll come to you in just a moment, Mr. Rankin. I want to try to understand what's going on here because this is getting interesting. So you just asked me a moment ago about consolidating cases. Now, I have the 26328 case in front of me. We already called, let me get it here in my own pace here. Okay, 26252. Which cases are you asking to consolidate?
I don't see 26252.
That was number 23 on the docket. We discussed the pre-hearing order for October 20th or 27th. We're waiting to hear from the parties. Mr. Rankin has objected. That was the one where negotiations fell apart recently, and surprise. Anyway, so that was the case I called earlier from Longfellow. Were you thinking of another case?
Yes.
But not on today's docket.
Correct.
Very good. Okay, so we're not worried about 26252, but we are talking about 26328. What are you thinking of? What do you think of joining 26328 to what case?
I guess to these, but I think there's some procedural questions here and probably some factual questions. I mean, the extension we're allowed to request as a matter of right under the order. I think that's probably the cleanest case for purposes of disposing of the situation. Spur has filed this application to reopen because, well, I'm not going to speak for Mr. Rankin, but as I understand it, they want additional information about the plan of development and the phasing of the drilling. So I think, if the extension is granted, we can just proceed under the order as a matter of course versus hashing through these issues and getting into, the reopening and all these other things. Not to say it wouldn't still go to a hearing, but I think that might be a cleaner way to proceed.
Okay, so then on second thought, you don't want me to join 26328 to any case?
That doesn't need to be, but the Spur case 26288 and the Longfellow case 25572 can be joined.
25572. Have I called that case?
What is that?
I don't know. Mr. Swazo, what case are you talking about?
You have not called that case. We're talking about 26238 and 26288. So those are the ones we're proposing to consolidate.
Which case numbers?
26288 and 26238.
6238. I don't have either case on today's docket as far as I know. Am I wrong about that?
26328.
Oh, 26328. Ah,
Yes.
okay. 26328. Let me start over here. 26328.
I might have misspoke. My apologies.
That's okay. I just want to be clear. 26328, you're thinking of joining with which other case?
26288.
And have I called that case today?
No.
Well, then why don't you file a motion and
Okay.
get Mr. Rankin's position on it? Because I don't have enough information to even understand that right now. So back to your case, Mr. Suazo, and I know Mr. Rankin probably wants to say something at this point, but how do you want to proceed on this case?
We're prepared to go to hearing on September 1st as currently scheduled.
Wait, as currently scheduled. I thought that was a different case number that's going to hearing on September 1st. Am I wrong about that? Because that's a spur case. Mr. Suazo, the case that's going, I think, Freya, will you help me out? What is the case number that's going to hearing that Spur filed an application for all the things that Mr. Suazo mentioned, and I think also the different bench that the well was put in? What case number is that?
26288.
Okay, 26288. Mr. Suazo, 26288 isn't on today's docket.
Hang on, I think you confused me now too.
Oh, I confused you. Mr. Suazo, do you want to come back to, how about if I go in recess on this case and we can come back to it after the next case? Is that okay?
That works.
All right, excellent. We're in recess. Let me just put a big R here. We're in recess on that Longfellow case. Let's go to NSP Resources 26329. That's not joined, it looks like, so I'm just going to call it by itself. Entries of appearance, please.
Jacob Everhart with Beatty Wozniak, New Mexico, appearing on behalf of the applicant North Star Resources.
Thank you.
Good morning, I'm sorry, I'm going to cut my colleague off here. Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Permian Resources Operating LLC, who objected, and also MRC Permian Company and MRC Delaware Resources LLC, who also objected, and then also entering an appearance for Mewburn Oil Company, and we're monitoring only.
You're monitoring
For
only
Mewburn.
For Mewburn.
For Mewburn.
Okay, and is it your intention to file competing applications?
For any of my, or
Yes.
any of the
Yes.
parties, as of right now, sorry, I'm just looking over my notes. Yes, for Matador, we will be filing competing applications, but I will say, I did have some email correspondence with Mr. Everhart yesterday, and my understanding is that NSP is agreeable to another status conference in September.
Okay, well, I just wanted your position for now. So I think I understand that Matador is considering filing competing applications.
Correct.
Do you know if proposals have been sent out?
I believe so.
Okay. All right, Ms. Bennett.
Good morning, Mr. Hearing Examiner Dina Bennett on behalf of Avant Operating 2 LLC, and we're monitoring only to preserve
Monitoring, okay.
Avant's rates.
Very good. Mr. Everhart, do you?
One more. One more.
Oh, excuse me.
Jackie McLean on behalf of Marathon Oil Permian, and we are also just monitoring.
Monitoring. Thank you, Ms. McLean. Mr. Everhart, were you aware that Matador had sent out competing proposals?
Correction, can I?
Yes, by all means.
I don't have confirmation that they have sent out
You don't.
proposals.
Okay, well, let's ask Mr. Everhart. What do you know, Mr. Everhart?
So we were not aware whether or not proposals have been sent out, but we are agreeable to another status conference next month for the 17th date.
Okay, very good. So September 17, it'll be the final status conference. In this case, Ms. Vance, please speak to your clients, all of them, and let them know that that is the final status conference. So if they are planning on sending out and filing applications, please do so in a timely manner.
Understood.
Thank you. Anything else, Mr. Everhart, in that case?
Nothing for me.
All right, and you don't want that joined with any other case, is that right?
That's correct.
All right, very good. Let's move on to 26330, NSP Resources.
Jacob Everhart with Beatty and Wozniak, New Mexico, appearing on behalf of the applicant North Star Resources.
Thank you.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Permian Resources Operating LLC, who is objecting, as well as MRC Permian Company and MRC Delaware Resources LLC, who is also objecting, and then Mewburn Oil Company, who is monitoring only. And this is another instance. I did have some communication with Mr. Everhart and his colleague, Mr. Suazo, and we would like to ask for a second status conference in September. And that's all I have.
Okay, we have some other entries of appearance.
Yes, Jackie McLean on behalf of COG Operating and Concho Oil and Gas, and we are just monitoring.
Perfect, thank you. Ms. Luck? Mr.
Sorry,
Everhart,
Mr. Hearing Examiner, Caitlin Luck appearing for Waterloo Resources. I apologize. I didn't see this on the docket worksheet. Thank you.
Okay, so you're representing Waterloo Resources. I don't know your position.
No objection. We're just appearing to preserve rights. Thank you.
Okay. All right. Mr. Everhart, how do you want to proceed?
Yep, we are agreeable to another status conference next month on the 17th.
Okay, it'll be the same as the previous case. It'll be the final status conference.
Understood.
So again, Ms. Vance, please discuss this with your clients and let them know.
Understood.
All right, thank you. We're off the record in that case. Let's go back to Mr. Suazo's case, the Longfellow Energy case, 26328. Mr. Suazo.
Yes, I think we got some clarity, at least I hope so. So what we're proposing for Spur's application to reopen, which is going to contested hearing on September 1st, that is 26288. And then the extension case is 26328. We think those two cases should be joined ahead of the contested hearing just because they have overlapping issues, but still deal with the same underlying matter, which is originally case 25572, which resulted in the order that is at issue here.
Mr. Rankin?
Thank you, Mr. Hearing Officer. Yes, so as just a reminder, this may just to kind of crystallize all the discussions we've had and the issues here. We're at issue in this case is Longfellow's compulsory pooling order for its petty development, petty wells. And upon receipt of the well proposal under the pooling order, we had a concern, Spur did. And that's what elicited this whole dispute over timing, development, sequencing, are they going to do what they said, all that stuff. So we, after learning that that they were going to change their plans, we asked for them to confirm with the division, go through the process. It didn't happen, so we filed our own application to reopen the pooling order to get the pooling order amended to conform with whatever their plan was going to be, because we were still trying to figure out what their plan was, okay?
So your objective was to get the pooling order amended, okay?
Yes, correct. To whatever their plan was actually going to be.
Okay.
Okay. Subsequent to that, and subsequent to getting a date on September 1st, which is a date that does not work for me. It didn't work for me then, it doesn't work for me now. We, Longfellow then, independently on its own, filed an application to amend the same order that we're seeking to amend, okay? Doing what we said was inevitable because they weren't going to be able to meet their deadlines. And so now we're back to where we think we should be, which is that we have some sort of a, acknowledgement from them that they have to amend it.
Okay.
we have, as part of the efforts to reach an agreement, we were very close. I want to say again, very close. We had deferred their deadlines to provide us documents under the subpoena twice until today. So I talked to Miguel and Mr. Suazo yesterday, and I understand that they are preparing to produce those to us today. I'm leaving tomorrow to go to New York to take my son to college, and I will not be here when exhibits and testimony are due, which is why September 1st didn't work for me. Also, we won't have much time to review what their development plans are based on the documents we received from Discovery. I believe, and I'm going to urge the division to push back that September 1st date to allow us time to review the documents that we received today to understand what actually is at issue. Because we know now that they're going to move, that they want to amend their pooling order. We've asked for confirmation of what their development plans are. We don't know yet, so that's why we had to get the documents. We will see those documents now. We're getting them on Thursday, by the end of the day, hopefully today at some point. We'll have Friday, maybe Monday, but then our exhibits are due on Tuesday. We won't have time to really review them effectively. And I'm going to be gone. And frankly, attorneys actually have a lot to do with, when we put cases on, looking at the documents, understanding how it relates to the testimony. I'm going to have zero opportunity to be involved in that, which is not, I don't think, correct. So I'm going to ask the commission that we push that date back to allow Spur internally and myself to review the documents to understand what their development plan is, to give us time to incorporate that into a more hopefully narrow and targeted testimony that addresses what we don't yet know, which is what their plan of development is going to be. So all that to say, since this whole thing got set up and we have a contested hearing, Longfellow now itself has filed for an amendment to their pooling order, which is what we wanted them to do. And but we just need to figure out what they're going to do, what their plan is, and all that sort of thing. So I'm hopeful that we can get documents that elucidate the plan that we can then target with our testimony and be more focused. But we need time to do that, and we don't have time to do that with the current setting. And I'll just say that our agreement to extend the subpoena deadline was not intended to prejudice us or Spur in any way, and I don't think it should be used in that or be used as a punishment, because we were working with them to try to, number one, get a global resolution, and number two, give them the benefit of the doubt so that we can work cooperatively together. So if the September 1st date is held, that is a severe prejudice to me, and in the future I'm going to tell my clients, don't give them an extension, make them produce the documents, because we're going to get held to the fire and not have an opportunity to adjust our deadlines. So I think that's a bad outcome. So I'm going to ask the division to help us set a different date to hear this matter. I think it'll be more efficient for the division and the parties, because we'll have the ability to actually look at the documents and focus our testimony. So I'll turn it over to Mr. Suazo if he has additional comments on that, but I think it would be very appropriate for the division now, given the change in the status, to give us a little bit more time.
Thank you, Mr. Rankin. Mr. Suazo?
Sure. So a number of things. I think we need to level set as to the extent to which, this order actually needs to be amended. Spur has had this information for a long time. The only thing that's going to change based upon the amendment or the extension would be the sequencing. And there is some, factual disputes over whether the depth change, which is minor in our view, and I think the division has agreed with us, through informal analysis. But, we intend to abide by the subpoena. We will get Mr. Rankin those documents today, but these are not going to be voluminous documents. This is just going to be, probably largely information he already has. And then we can deal with kind of the underlying issues, which I think are relatively minor at the contested hearing. So, if Mr. Rankin is not available on the 1st, I did note that the division is making some availability on September 1st or September 15th. And, that would be the outer limit of where Longfellow wants to have this contested hearing, just because I think, it's important to recognize the levels at issue are not particularly different from the application as originally proposed.
Mr. Rankin, when did I issue that subpoena?
It's been some time. It was stayed for a period of time by sua sponte, Mr. Hearing Officer, because Longfellow then filed an application to dismiss our application to reopen. They filed a motion to dismiss our application to reopen. And so the division stayed the effect of that subpoena to allow us to brief whether the motion or application to reopen should be dismissed. And so it was stayed for a period of time. And then once that was decided, it was reactivated. Mm-hmm. And then we, at that point, then started getting into discussions with the parties about potentially resolving all these issues, which would have been the best outcome. And I think we all agree it would have been the best outcome.
Could we go back to the question, though? The question is...
Yeah. When was it? Yes, I don't have it in front of me. I think
I have that in front of me.
Thank you.
If
Mrs.
my
Weiser?
notes are accurate, it looks like the subpoena was at least sent to the division on June 24th. And I don't know if that's actually when you issued it, but I think you issued it either the same day or the day after.
Sure. I cabined it slightly and issued it. Then there was the motion to dismiss, which I then stayed the subpoena because I felt like, what is the point of producing these records if the case is dismissed? Based on the response, I denied the motion to dismiss. Can you tell me what is the date that I denied the motion to dismiss?
Yes, give me just a second.
Mm-hmm.
That was July 17th.
Okay. So and then in that order denying the motion to dismiss, it says that I lift the stay on the subpoena. Is that right?
Correct.
Okay. So, Mr. Rankin, it's been a month. That subpoena had a 20-day deadline, if I'm not mistaken.
Correct. And then 10 days before, or a week before that deadline, Mr. Suazo asked for an extension.
Okay.
Because we were in discussions.
Right. I understand.
And we gave him that extension, and then we gave him another extension. So we gave him 2 extensions.
And you said we. Who's we?
Spur.
Oh, not you.
I have no authority to give him an extension, okay. But the client did. And the client was in discussions that were very productive, and They had an agreement in principle that they were trying to paper up.
I get it.
Yeah.
You know, I understand that perfectly. And now you're saying, and so Mr. Suazo is saying that the information you're going to get today is largely information you already have. That's what he's saying. I take representations at face value. So Mr. Suazo, why do you say that?
Because I just, based upon discussions with the client, and I haven't had a chance to personally review all of the information, but my associates have, and it seems like, you know, the information that was made available or submitted with the division when this application was filed, which resulted in the order from last December, is going to be fairly consistent with, you know, the information that we have presently. And so this is not like it's going to be, you know, a huge factual change requiring, you know, changes of posture from Spur. This is just showing them what we have. The only thing that is going to change is however this is disposed. Longfellow wants the opportunity to drill all of the wells contemplated by the order next year. And that right is, you know, given to us under the order, which is why the extension request was made.
So, Mr. Rankin, help me understand something. This September 1st hearing set on your case, I mean, you have the burden of persuasion in your case. I set that, Mr. Suazo, since you seem to have the records in front of you, when did I issue the pre-hearing order for September 1st?
I think it was also July 17th.
Do you have any reason to disagree with that date, Mr. Rankin?
No, but even as of that date, I knew that the deadline to file exhibits was going to conflict with my being out of town. So I knew at the time I was asking for a middle September hearing because I wasn't going to be able to do what I needed to do for preparation of the hearing.
I was mistaken. It was July 23rd, Mr. Examiner.
Okay.
But
All right. And Mr. Suazo, I gave you September 1st because I think I found your argument persuasive that you were in the middle of drilling wells and that you, as I remember, and I'm not looking at my notes at this point, but you had already drilled one well, you were producing, that you had other wells that you were drilling. Help me refresh my memory.
One well for sure. I'm not sure the others were being drilled.
Okay.
There's, I think, 8 or 9 wells with this application. And so
Right.
we're looking at, the balance of these wells just being extended into early next year.
Right. Okay. All right. And so, Mr. Suazo, you said a moment ago that September 15th works for you. Is that right?
We can make that date work, yes.
All right. I'm not going to change this again, Mr. Rankin. That's the date, September 15th. That's a final setting. So if you're not ready on September 15th, the case will be dismissed.
I've asked my folks to make sure to confirm that date works.
Okay. We can always keep September 1st if it doesn't work for the 15th. But I will offer you the 15th based on what I've heard today. So when will you let us know?
I've got requests out as soon as I hear back, and I can tell you as to the other matter that we have in the same group of cases that are related, the Almond cases that we called. You asked me to confirm with the client about availability.
Can you give me case number because I don't remember?
I will. One moment. It's case number 26252. It's number 23 on the worksheet.
Number 23. Okay, I see it. Longfellow Energy, yes.
Spur is available on 10/20 for a contested hearing. They're not, and I don't believe Spur is either. Longfellow is either because they're in a mutual other matter together on that following week. So 10/20 works for Spur.
Does that work for you, Mr. Suazo?
Just so I understand, you're asking if 1020 works for the Almond case that you called earlier or for these cases?
That's right, the Almond 293 CDX case, yes.
I'll need to check with my client to make sure that date works. I don't know.
Okay. All right, then we'll wait to hear from you. But now I understand that the 27th is not an option.
Right. And then I just heard in the interim, Mr. Hearing Officer, that the September 15th date for this petty consolidated case will work for Spur. Okay. So with permission, I will work with Mr. Suazo to prepare a motion to consolidate and a proposed order, and we'll get that filed shortly after today's hearing.
All right. So we're talking. Well, hold on, Mrs. Suazo. I got to go one step at a time. So Mr. Rankin, you're talking about consolidating the amendment case 26328 with the case 26288 that's going to hearing now on the 15th of September?
Correct, and we'll also file a request to continue the case to that date.
To amend the pre-hearing order, yes. Mrs. Suazo, what were you going to say to that?
I was just going to say that I was able to confirm with my client that October 20th works.
Okay, great. So we have October 20th for the other case, 26252. Now we're still talking about the case I called 26328, and we're referencing 26288. Mr. Suazo, is that okay to consolidate the two cases together?
Yes.
All right, very good. So 26288 will be consolidated with 26328, and they will both proceed to a hearing via an amended pre-hearing order that Mr. Rankin will file a motion to accomplish, I guess, very soon. And we will issue an order amending the pre-hearing order to September 15th. All right. Anything further from you, Mr. Rankin?
No, I appreciate it. Thank you.
Yes, you're welcome. Mr. Suazo?
No, thank you, Mr. Examiner.
All right. You're welcome. Okay. The next case on the docket is EOG Resources. It looks like we have 4 cases that are consolidated together, 26336, 3739, and 41. Entries, please.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of EOG Resources.
Thank you.
Mr. Hearing Examiner Darren Savage with Aberdeen and Shill appearing on behalf of Coterra Energy Operating Company.
Thank you, Mr. Savage. What's the position?
The position is that we filed an appearance and we object to this case. The parties, we have been trying to, we're very open to a resolution, been trying to work a trade. This case has some interesting factors and characteristics. If I can go through and describing these, but basically, Coterra owns 100%.
Keep the description very short.
Well, I'll just initially, and then if you want more.
Okay,
so Coterra owns EOG is proposing to develop 36 and 25, and they are stacked.
Yep.
Coterra owns 100% of 25, 100% of 24, and if we cannot. Like I said, we're open to a resolution, but if we cannot, we plan to develop those.
Sure.
So there's some interesting issues about to what extent should a party be able to use state powers to annex 100% ownership of a sizable.
We'll just talk to Mr. Rankin.
I know, and I was going.
That's one of his favorite kicking horses or whatever you call it.
If I may, and I was going to mention that, but. Mr. Examiner, in 2025, there was a case, Cimarex owned and controlled all of Section 10, and another party attempted to file applications that would pool Section 10 and Section 3. In that particular case, at that time, those applications were ordered to be dismissed, and that was there's an issue there that was recognized and picked up on about the validity in that situation. Now, currently, as I understand it, the commission is reviewing this particular issue, and that's case 26206.
I don't think they're reviewing it. It hasn't gone to hearing.
It hasn't gone to hearing. I believe in October it goes to hearing, and it has some similar issues, some of the same issues, but I believe. Our situation is distinguishable in that in that case you're looking at a 160-acre sliver of
80 acres. I thought.
Oh, 100. I thought it was north half of Section 2.
So it's 160.
Yeah.
Okay.
So you're looking at a 160-acre tract, which commercially could be developed, but it's smaller than 1,280, for example, and it's smaller than the full section 640. So I think it's distinguishable.
Okay.
So what we ask, these applications were filed July 8th, 2026. This is the first status conference. We would like some time to negotiate, if that would be possible, and taking those into consideration that possibly the commission case may decide some issues that may be dispositive in how we evaluate this situation. So that's. Yeah, thanks.
Thank you, Ms. Savage. Ms. Hardy.
Thank you. So EOG started talking with Coterra about these wells in October 2025. And initially we filed our applications in January of this year. And because then we learned there were 2 pools in this acreage, we dismissed and refiled those. And the only change was that we separated out the applications to include the wells in each pool. So there's no change in the wells. So this has been going on for a really long time. EOG and Coterra each hold roughly 50% of the acreage. And
in the same acreage?
So there's one section,
Yes.
Section 24 and might not have the sections right, but there are 2 sections of land, and Coterra owns in one section and EOG owns in the other. There's nothing novel at all about pooling acreage that a party owns 100%.
Okay.
It happens all the time.
Okay.
And the division in that situation looks at the competing plans and determines which plan is better for the acreage. So there's nothing novel about it. EOG is ready to proceed with this development. and would like to set a contested hearing really as soon as possible, and is certainly available in the October 20th docket.
All right. Mr. Savage, do you dispute any of the dates about the discussions beginning in October of 25 and the cases originally being filed in January and then dismissed based on what Ms.
No,
Hardy just said?
that's correct about the dismissal and the refiling. It was I don't know what the nature of the initial discussions were. I don't know if they were more superficial and more in passing, but I was informed that the current discussions were getting close to some kind of fruition.
Okay.
That's what I was informed.
Okay.
So,
well, if we set a contested hearing for October 20, which is what Ms. Hardy is asking, that still gives 2 months for your client. I mean, that's almost a year from when the original proposals went out. So it seems enough time to me. So is there anything else, Ms. Hardy?
No, thank you.
Okay. Anything else, Mr.
no,
Savage?
thank you.
Thank you. All right. Why don't we take a 5-minute break? I don't even know what time it is. It's 10:30. We've been going for 2 hours. Let's take a 5-minute break and come back and finish up this docket. Off the record. All right, we're back on the record. It is 10:40 a.m. and I'm going to recall the first 4 cases on our docket for Matador Production. Ms. Vance?
Yes, Matador is good with the October 8th docket that was offered.
Yes, October 8th, we'll issue a pre-hearing order. So we're in recess on those cases. I'm recalling cases 14 through 17 on our docket for Matador Production. Ms. Vance?
Matador is good with the October 27th contested hearing date.
Okay, October 27.
And I did hear from Ms. Hardy. BTA is also available for that date.
Thank you.
Thank you.
I appreciate that. Thank you, Ms. Hardy. Okay, so we have October 27 for those cases, and we're joining case 26398 to those 4 cases.
Yes.
Okay, very good. And then finally, I'm going to recall case 18 and 19, Permian Resources.
Yes, that one, the October 27th contested hearing date works for us.
Very good. So October 27, and Ms. Vance, you're involved in that case, aren't you? Those cases?
No, that's me, Ms. Bennett.
Oh, I'm sorry.
That's okay. Yes, I am. And I had proposed October 27th.
Oh, you did?
Yes. I haven't really conferred with Coterra, but I mean, that's the date I'm available, so I'm hopeful that that's the date they're available.
I understand perfectly. Okay, we'll issue a pre-hearing order. Were there any cases to be joined, Ms. Bennett? Because I didn't even have that down. I had Ms. McLean. I had Ms. Vance next to XTO Energy. We are talking about 18 and 19 Permian Resources, 26222 and 26223. Is that right, Ms. McLean?
Yes, the metallic cat cases.
Yes, metallic cat cases. Very good. So Ms. Vance, I did have you, was that wrong? Did you not?
No, that's correct. We're monitoring, so we're fine with whatever the parties agree to.
So you're monitoring. So Ms. Bennett, will there be competing cases?
At the moment, Coterra is hopeful that they don't have to file competing cases, but they are considering counter-proposing at the moment.
Okay. All right. So you understand the deadline, so we're good there.
I do.
Very good. Thank you. So October 27, we have that date cleared up as well. All right. Now we're going to move on to some new business. We were at number 41 on our docket when we last broke, and that is 26338 Marathon.
Sorry, I'm just getting there.
It looks like Holland and Hart.
Yes, okay. Yes, Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Marathon Oil Permian.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2. And Avant we did file an objection to the case proceeding by affidavit, but last night Avant let me know that Avant intends to withdraw its objection and to participate under the proposed JOA. Avant had been hoping to reach a different agreement, but they don't want to hold up Marathon's development, so I'll be filing a withdrawal of objection today.
Okay, very good. Excellent. So Ms. Vance, you're going to move your case to the next hearing by affidavit docket?
Yes, we'd like to continue to the September 3rd docket.
Let me make a note. All right, and since it's an older case, it's not very old, but since it's an older case, Freya, we put that toward the front of the docket so we can make sure it doesn't get bumped?
Yes.
All right, thank you. All right, Ms. Vance, anything else?
Not from me.
All right, thank you, Ms. Bennett. All right, let's move on to Mewburn Oil. We have several cases here that we can consolidate and discuss together. 26340, 42, 43, and 44.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Mewburn Oil Company.
Thank you.
Jackie McLean on behalf of COG Operating, and we are just monitoring.
Thank you, Ms. McLean.
Good morning again, everyone. Ben Holliday on behalf of Earthstone Operating and Permian Resources Operating.
Do you want to tell us what your position is?
Yes, we entered objections in these cases. Permian and Earthstone have competing development plans for the acreage. Proposals have been sent out. That process is maturing. Once it's ripe, they intend to file competing applications.
And when do you anticipate that?
Proposals were sent out, I believe, a couple weeks ago. I believe they have a week or two to go before they're ripe for filing applications, but I would anticipate within the next 20 days, the applications will be filed.
Okay, Ms. Vance?
Mewburn would like to request a contested hearing date. Based off of what Mr. Holliday just spoke on, I would say Mewburn's fine with either the October 20th or October 27th contested hearing date. And I'm assuming Mr. Holliday will want the October 27th, so we're fine with that.
Okay, Mr. Holliday?
I haven't conferred with Permian about setting a contested hearing date. If one were imposed right now, I believe the 27th would be preferable. That would give us time to submit our applications. Our preference would be one more status conference, but happy to accommodate the division's preference.
Okay, well, they're Ms. Vance's cases for now. So if she wants to have another status conference,
we're good with that.
Continue them to September 17. But we'll issue a pre-hearing order for the October 27. And Mr. Holliday, when you do get some case numbers, would you file a motion to consolidate?
Yes, sir, absolutely.
All right, then is there anything else, Mr. Holliday?
Nothing from Permian or Earthstone, thank you.
All right, thank you. Ms. Vance?
No.
Let's move on to another set of Mewburn Oil cases. 263, 55, 56, 57, 59, 60, and 61.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Mewburn Oil Company.
Thank you.
And Jackie McLean on behalf of Permian Resources Operating. And we have objected.
Okay, and your intention is what?
Our intention is to send out well proposal letters in the next couple of weeks.
Okay.
And we actually talked with Ms. Vance yesterday. We had proposed another status conference, hopefully in October, because these cases, ours would not be ready to go to hearing until then.
Okay.
And I think that idea was rejected. But that's what I have for right now.
Perfect, thank you.
If
Ms.
I may,
Kessler?
Mr. Examiner, Jordan Kessler with EOG Resources monitoring this case.
Thank you, Ms. Kessler. You could make a recording out of that, don't you think? Ms. Vance?
That's correct. My understanding is Permian owns a very small interest here, and so we would like to move forward as soon as possible. These were filed at the beginning of July, and so there's been some time there. And from Mewburn's point of view, they just want to move forward. If Permian would like to do a status conference next month, we're open to that, but we would like to set a contested hearing date for October 20th. And I understand, Ms. McLean's concerns about ripeness, but we would ask for things to keep moving along and for that contested hearing date in October.
Freya, have you been counting how many are on the October 20 date? Sorry, Ms. McLean, hold on one second.
I haven't. We already have 2 that were set at a previous docket, and I haven't been keeping track of today's.
Okay, well, I have, and there's many of them. So November 3rd would be the earliest we could set the case for a contested hearing. Does that work for you, Ms. Vance?
I'll have to confer with my client.
Okay. So you'll let us know today?
Yes.
Okay, and we might be here for a little while because this next case may take a little while, so you have some time to confer with your client if that works. Ms. McLean?
I would just like to say if we have to set a contested hearing date, like maybe not November 3rd either, but further out, because we have many cases set for October 20th and 27th at this point, that the exhibit deadline, all of that is going to make it extremely hard. And, for these cases, this is a first status conference. It's not like this has been hanging around for that long. So, we would like to push for just another status conference at this point, and then let's reconvene on a contested hearing date at that point. I'm sure the November docket will still be an option, but we can maybe see if some other cases have cleared out and what's happening between the parties.
Ms. Vance?
That doesn't work for Mewburn. We want to set a contested hearing date as soon as possible. Again, Permian owns a very small interest here, and so we'd like to move. There's time for the parties to continue negotiations between now and a September status conference. And I'm not sure what the count is on where they are in terms of contested hearings for October 20th, but right now that looks open for us. And if we had to do November 3rd, that work, I'm sure that's going to work for Mewburn because they want to move quickly on this.
So, Ms. McLean, I agree with you. The cases aren't very old. There's no question about that. November 3rd is quite a ways away still. I see how many cases actually go to contested hearing, and that would be few and far between. I don't have a great reason not to set it. Ms. Vance is asking for one with a very firm tone in her voice, sort of that Coast Guard tone that she's practiced.
Commander Vance.
Sorry, Ms. Vance, Commander.
05.
Commander Vance tone. So we'll issue a pre-hearing. Please discuss with Ms. Vance if that date doesn't work for your witnesses, but we'll issue a pre-hearing order and we'll expect to see these cases again in September on another status conference docket. Anything further, Ms. McLean?
I guess not. Thank you.
I guess not. Okay. Ms. Vance?
No.
Oh my. All right. All right. Okay, that leaves us with one case, a case which I have been looking forward to. This is case 26365, Enduring Resources.
Good morning, Mr. Hearing Officer Adam Rankin with Santa Fe Office of Holland Hart, appearing on behalf of the applicant in this case, Enduring Resources.
And before I go to Mr. Beck, what is Enduring asking for?
Well, this is a federal unit that has final approval from the BLM. There is I'm not sure exactly the status of the expansion. I think they're adding 1,500 acres or so of additional acreage that they've asked the BLM to include in the unit. I'm not sure if there's final approval for that additional acreage or not, but as has been the practice with federal exploratory units, when we appear before the division to confirm the existence of the unit and get an order, recognizing the unit for purposes of the division's administrative review and approval, so they can correctly reference the fact of the unit when they issue APDs and other authorizations related to the unit.
Okay. Let's have the other entries of appearance.
Morning, Mr. Hearing Examiner. Matt Beck, Pfeiffer, Hanson, Mullins, and Baker on behalf of Epic Energy, LLC.
And your client's position, Mr. Beck?
The client's opposed. There's several disputes, I think, between Enduring and Epic, all centering around Enduring drilling wells and completing wells and stimulating wells within the same area as Epic continues to operate vertical wells without providing notice of the filing of APDs, filing for permits, drilling, and they have damaged irreparably a dozen or more of Epic's wells. And so Epic is now put in a position where it has to oppose at this level everything it does. We talked, the hearing officer heard earlier about the importance of notice in the adversarial proceeding. And that's basically what Epic is asking for, is notice of when they're filing APDs, when they're going to drill. And without that, Epic's put in the position where it's just going to continue to have its business interests irreparably damaged.
So, Mr. Beck, and I think there's a few other entries of appearance. I don't know if we have the Whitleys with us. Well, all right. Freya, do you know if the Whitleys got notice of today's hearing?
I would need to confirm.
Okay. In the meantime, Mr. Beck and Mr. Rankin, you probably know that Mr. Beck filed, I think, about 13 applications to revoke.
I'm sorry, can you guys hear us? I apologize.
I can hear you now. Who is this?
Yeah, sorry, my name is Jesse John Whitley. I don't know if my brothers know that they need to hit *6 to unmute themselves.
Okay. Are you entering an appearance, Mr. Whitley?
And one of my other brothers wanted to talk, but I just didn't hear any of them speaking, so.
Oh, yes, sir. Sorry about that.
Oh, there he is. Go ahead, Brandon.
Yeah. Sorry, Six. I apologize about that. Yeah, my name is Brandon Whitley, and we're appearing pro se on ourselves. Myself, Jesse John Whitley, and Aaron Dale Kemp, all three of us are currently on the line as well, sir.
Okay. And you've entered an appearance for what purpose?
Mine mostly, well, all three of us actually, we want to make a statement if possible, about a minute and a half if we can have the time. We did get some new information that was sent to us yesterday afternoon. So we only had, less than half a day to review some pertinent information that was sent to us.
Okay, so Mr. Whitley, Mr. Whitley, let me ask you some questions because you're pro se and this might be helpful. Are you mineral interest owners?
Correct. Yeah, we're inheritors.
Okay. Let me ask Mr. Rankin a question. Mr. Whitley, give me a minute. Mr. Rankin, are you aware of these pro se litigants?
We are, and okay. I can briefly explain their situation.
Yes, thank you.
They are part of an unprobated estate. So there's an acreage or a tract that's within the exterior boundaries of this unit, but it's in they're working interest owners, or their predecessor in interest is working interest owner of a federal lease. But because their estate is unprobated, we can't do anything with it, and the BLM can't do anything with it. So I understand that there's now a probate action in New Mexico. So we just have to wait for that to play its course. And I'll just say that Enduring has been in contact with these folks and is answering questions and addressing whatever questions they have as much as possible. So that's happening separately between these pro se folks and Enduring's personnel.
Did Endurance send notice to these people?
They, because it was unprobated, it was sent to the estate of each of the parties who remain unprobated. So all of these folks, based on the estate, got notice. So it was not to their individual names, but it was the estate, because that's the current legal entity.
I understand.
Yeah.
So, Mr. Whitley, both of you, we're here today for a status conference. We're trying to decide how to proceed with this case. It's Enduring Resources application, and it's an application to add about 1,500 acres to this federal unit.
Yeah, I think actually just to acknowledge the entire federal unit as well as the additional 1,500 acres, yeah.
Okay, and so Mr. Whitley's, are you opposed to this application, or are you not opposed?
That's an excellent question. Not necessarily. We're more concerned about the ratification forms that they're sending out, saying that whatever decision we make is going to be affecting us and our bloodline heirs going down, and they're not giving us all the information. Let us know what they're ratifying to begin with. And this new information that was presented to us yesterday, we haven't had a chance to kind of go over it. And a lot of their numbers don't even make sense. And some of their spreadsheets have errors on them. So we're getting some information right now. Like I said, we just received it yesterday. But a lot of it based upon what they're saying that they want. And then they want us to sign these ratification forms. And based on what they say, they don't correlate very well.
Okay, so you entered an appearance. In your entry of appearance, did it say that you object to this application?
At this point, we're not objecting until we can get full information on what exactly that.
Okay.
Okay.
Yeah. All right, good. So then just listen in. And Mr. Rankin, I expect Enduring will continue to send out all the required information to the legal entity.
Correct, and since we have their contact information, the landmen at Enduring are staying in touch with them and keeping them apprised of status and so forth. Yeah.
Okay, all right. So, Mr. Whitley, you're more than welcome to listen in and participate by listening. But since you haven't entered an objection, just listen, okay, for now? Because I'm trying to understand the objection that Epic Energy has filed, because they have filed an objection, and that would prevent this case from moving forward as in a simple way. I'll speak in simple terms, and it would have to go to a hearing, which you could, of course, participate in if it does go to a hearing. So just listen in for a moment. So Mr. Beck, back to Epic Energy, and Mr. Rankin knows that Epic Energy has filed the 13 cases to revoke to basically revoke orders to APDs, excuse me, APDs, aren't they?
Yes.
That's what I thought. Okay. Because you're saying that you did not receive notice of these APDs?
Right, that's correct.
Okay, fine. And I don't understand the APD process because that's in the technical bureau and I don't deal with that at the hearing bureau level. But what notice is required for an APD?
Notice of the application of the APD for operators within the unit. I don't have the language in front of me. I think it's 1915, 1512B. And so under that OCD rule, when Enduring is applying for these drilling permits, it should be providing notice to those within the spacing unit or proration unit.
And you are within that spacing unit?
Yep. Some of these wells, I think, are within 0 feet of where they've drilled.
So, Mr. Rankin, is that the case?
Well, this gets into the merits.
Well, we don't get in the merits, just give me the legal overview.
Sure. So there's a whole separate arbitration fight going on right now between these parties that's actually in hearing today. I just got back from it. But there's a separate dispute going on between these parties over some of these very issues. And there's a separate agreement, contractual agreement that the parties have entered into that governs, actually it was the predecessors to each party had entered into an agreement that governs the relationship and operations over all the leases at issue between these parties. Okay. So that's a separate issue. And what I understand Mr. Beck to be saying is that Epic has concerns and objections to the filing of wells, the applications for wells. This case has nothing to do with wells.
Okay.
This case has only to do with the consolidation of leases for purposes of creating a voluntary unit. Okay. So there is no issue about wells or spacing or offsets or setbacks at issue in this case.
Okay.
That's number one, and that's the main thing I want to say.
That doesn't answer my question about does Epic deserve notice, even if there is some contract between the parties. Doesn't the rule say that they need notice not in this case, but when you file your APDs, don't you need to give them notice?
No.
Oh, okay. Why is that?
Because under the rule, okay, there's a rule that provides for notice it addresses notice for APDs.
Yes.
If applicable. If you I don't have the language in front of me, but it's 1914, whatever it is, 1915. I can't remember the number. If applicable. Okay. These are number one. These are all the. I'm not sure about the wells they filed on, but the ones that had been in dispute are federal APDs.
Okay.
Okay. One of the provisions that Epic is setting to applies to state APDs.
Okay.
Okay. So there's a whole argument about what is required when you're filing a federal APD versus a state APD. Okay. Number one. Number two, the second provision that Mr. Beck was citing to in particular, okay, has been superseded by the horizontal well rule, okay, which governs horizontal wells. Okay. That rule, okay, and I can go through, if you look at the transcripts in the horizontal well rule that was first promulgated back in 2012, what the division did is said, look, we have concerns about there being conflict or interactions between vertical wells or these existing wells and new wells that are being proposed to be drilled horizontally. And so we want to make sure that the parties are aware of the potential interplay between those wells. At the same time, we want the parties to be able to operate under their agreements that they have in place without having to do something that they didn't agree to do because they've got an agreement in place. Okay. And so they promulgated the rule back in 2012 saying that operators are required to give notice of their potentially overlapping horizontal wells if they're going to be in the same pool or formation, subject to any agreement the parties may have, okay? Subject to the terms of any agreement the parties may have. So that specific language is in there. So this is a whole fight that's going on outside of the context of the OCD right now. At least it was. Now it's being brought to the division. But so this issue before the division today on this unit has nothing to do with APDs, but only to do with the consolidation of leases on a voluntary basis for purposes of efficiently and effectively draining the Mancos Formation, which is aligned with about 15 other orders that the division has issued immediately offsetting voluntary units, confirming exactly what we're asking to do here.
So basically, you're saying that today's case has nothing to do with the APDs and notice, and we'll hear that at another time. So how do you want to proceed with your case today?
I think I'd like to get a hearing set as soon as possible.
Okay. Well, you don't really want it as soon as possible because that would be September 1st.
Yeah, I couldn't do September.
Right,
I personally couldn't do September 1st, but I mean, we could do, whatever the earliest date is available.
September 15th?
I would like to confirm with my clients.
That's the next one.
Okay.
I think I know them by heart at this point. So September 15th would be the next one. Mr. Beck, do you anticipate bringing witnesses?
I anticipate there would be probably one witness for Epic.
And you understand that this issue is very different from the issue that will control your cases that you filed recently.
I understand that's what Mr. Rankin thinks.
That's what he said.
I do understand that there are distinctions.
Okay, all right. Okay, so Mr. Rankin, I guess what we'll do is we'll wait to hear from you and your client by the end of the day.
Yes.
And please confer with Mr. Beck to make sure that his witness is available on the 15th of September as well.
Yeah, see if they'll ask our clients.
I've heard from our client that the 15th works for enduring.
Okay.
Yeah.
I'll reach out to our clients
Perfect.
and see.
Thank you.
Yeah.
Is there anything else, Mr. Beck?
No, Mr. Hearing Examiner, thank you.
You're welcome. Mr. Rankin?
No, it's been a fun morning.
It's been productive.
Yeah.
And now you can go off to Columbia University with your son and...
Oh, he didn't get in there.
Oh, where did you get in?
He got into Vassar.
Oh, Vassar, upstate in Poughkeepsie. Yeah. Well, okay. Hopefully he'll enjoy himself up there. Rhinebeck is a beautiful town, by the way. Oh, you've been there? Oh, okay. I grew up there, so that's why I'm saying.
You used to go to they used to have an air show there.
Yeah, well, sure.
Yeah.
Famous. Old Plains. Is there anything else before we're off the record? No. Okay, excellent. We're off the record. Thank you.